All right, good afternoon, everybody. Thank you so much for joining us for today's Lunch and Learn on managing risks of COVID-19 through contracts and operations, sponsored by Sachs, Dornberger, and Vita. A reminder that this is being recorded and will be available on community.franchise.org probably in about 48 hours. And if you have any questions for our speakers today, please put it in the chat box and we'll get to as many as we can at the end. All right, I want to welcome Richard Brown with SDV, who will introduce our speaker and get everything kicked off. Richard?
Thank you, Caitlin. Good afternoon, everyone. Thank you for joining us. My name is Richard Brown. I'm a partner with Sachs, Dornberger, and Vita in their Northeast offices. Just a little background here for those that I'm not familiar with. Sachs, Dornberger, and Vita is a policyholder law firm. We handle insurance coverage and risk management issues generally. We are a nationwide firm. We handle, like I said, insurance coverage issues and risk management, soup to nuts. So, you know, we deal with insurance policy drafting, review, manuscript provisions, disputes with insurance companies, claims handling, et cetera, right on through to litigation. I want to introduce Giovanni Urilla. I'll let you give an introduction here, but he is a longtime partner here with Planet Hollywood International. And Gio, thank you for being with us first and foremost, and I'll give you an opportunity to introduce yourself now.
Oh yeah, my pleasure. Yep, just here to help you guys out with the presentation and kind of go through some anecdotal kind of elements through the last 12 months or so in our operations. But yeah, as Richard said, we've worked together for quite a while now, and hopefully we can shed some light into our experiences over the last year.
Thank you, Gio. Again, we wanted to, we thought this was an opportune time to put some further guidance out in terms of the response to COVID-19. We're starting to see some light at the end of the tunnel in terms of reopening. The vaccine distribution is picking up and starting to see some success out there. So we're starting to see those numbers grow, and hopefully we can look back in a year or so time and really start to be out of the woods here with this COVID-19 pandemic. Before we get into the operational issues and what we feel are best practices in terms of contract modification, contract enhancement, and insurance modification and enhancement, you know, I wanted to just get into somewhat of a timeline here because some of these dates are going to be relevant coming up, particularly this month with respect to certain suit limitation provisions and also statute of limitation provisions. So dating back here, as we see to March 2020, we started to really see shutdown orders, governmental orders, state by state being issued there, shelter in place orders, things of that nature. Now, up until where we're currently at, February of 2021, throughout that period, there's been a number of, I'll call it starts and stops in terms of reopening and closures that have gone on that, you know, again, we're starting to see, I think, the light at the end of the tunnel. So right now, with the vaccine being out there and a number of states really reopening completely, we wanted to get into some of the issues that we feel have been identified as best practices at this point and make this somewhat of an experiential tool in terms of learning those best practices. And Gio, as you mentioned there, we have a number of issues that have come up operationally throughout that period, throughout that timeline, that have really had implications on the franchising community, franchise systems as a whole. And what we wanted to do was just get into some of those experiences now, and then get into best practices that are out there that we feel have really been effective in dealing with some of the exposures that have been created as a result of COVID-19 and the pandemic here. So why don't we get started here and discuss some of the closure issues and delayed openings and how Planet Hollywood and some of its affiliated concepts have dealt with these issues.
Yeah, sure. I mean, we've gone through the same pains as everybody in the hospitality industry, whether it's restaurant, hotels, what have you. But you know, the start and stops weren't beneficial. Obviously, when this all started, everybody had the kind of the hard-lined approach of, you know, shut everything down, no dining rooms. You can have delivery services, and that hurt us obviously because we lost the dining revenue, which is a big part of the majority part of the business. But luckily, you know, heading into all this, we had a good infrastructure for delivery, whether it's, you know, fulfilled by our own drivers or through third-party delivery apps or whatever, for the different brands. So we had that infrastructure, so we were able to kind of pivot very quickly and focus on marketing pieces that emphasize that. You know, on the third-party app carousel, we have a high priority. We have, you know, a long history with all those apps, so all their algorithms are based on that, on success and ratings, etc. But you know, that, you know, you can only get so much kind of blood out from a stone. So we really needed to open up that dining space, and luckily, you know, there's some states that started to do that and helped us through. And then, you know, the starting and stopping really hurt too, because, you know, states like California, where, you know, they opened or they closed, and then, you know, they told all the restaurateurs, you know, go ahead and spend, you know, $10, $15, $20,000 on expanding your exterior space, buying tents and beautifying a parking lot with planters and stuff like that. And then they shut that all down, you know, very quickly, and then shut us down for another 2 months or whatever. But now it's starting to reopen again. And yeah, like Richard said, we're starting to see a little bit of light at the end of the tunnel, where we're getting, you know, positive trends and no significant step backwards yet. So, you know, hopefully, you know, the beginning, mid, tail end of spring, we start seeing some favorable comps to 2019, and then kind of we'll go from there.
Now with the closures and delayed openings, I do want to come back to, you mentioned carousel there with the third-party apps, et cetera, and the delivery, but I wanted to talk about construction schedules to a degree, and you know, delayed openings, things like that. In our discussions, it's come out and it's been apparent that franchise agreements, operations manuals don't necessarily account for these situations on the whole. There have been a lot of after the fact, you know, I'll call it armchair quarterbacking there in terms of what is acceptable, what is permitted. Franchisees have looked for guidance from their franchisors, and it's been obviously unprecedented, the issues that have been faced as a result of COVID-19. So there's been a bit of latitude there, but you know, in your experience through this, do you feel, although Planet Hollywood and its corporate franchisor itself may not have made changes contractually, do you think that it's something that's going to be revisited at this point and further changes made, maybe with respect to indemnity provisions itself, addressing force majeure provisions and things of that nature that may not necessarily be tailored toward the interest of a franchisor, but some may say that it's better to have addressed these issues rather than left them undealt with, I guess you could say.
Yeah, yeah, we've taken a look. We have different concepts that we franchise. So Planet Hollywood, you know, to a lesser extent, but more maybe public facing, is obviously one of the concepts. But also we have Earl of Sandwich, which we do have 20 plus franchisees across the country. And you know, in terms of development schedules, we were in the process of expanding Chicken Guy, which is you know, a partnership with Guy Fieri. So you know, with the indemnification provision, I think we're pretty comfortable. It's very franchisor friendly in that respect. It's pretty broad, so we're comfortable that it'll kind of cover that. Force majeure, we probably will take a look at, you know, if something like this were to happen again in the future. But, you know, on the whole, you know, we've written a bunch of kind of abatements for the varying franchisees, because, you know, we're in the same business, so we understood and we abated any royalties, or we pushed back any development schedules. So we're working very closely with the franchisees to make sure that we're accounting for the tough environment.
Mhm.
And then on the development schedule, even for our corporate owned stores, I mean, I don't see us restarting any development until the summer probably of this year, because we kind of have to get the cash flows up before we start financing construction. So like I said, I think spring we'll start seeing some favorable comps, and then hopefully we can see that trend into the summer, and then we can start our development again.
I'll say that the conversations that I've had with most of the folks in the franchising industry, mainly on the franchisor side, they're largely in agreement, and they're kind of lockstep with what I've heard from you, Gio, in terms of your operations there. And you know, while the COVID-19 pandemic isn't necessarily addressed specifically in the current franchise agreement or operations manual language, you know, it's been amenable to, and the parties, franchisor and franchisee parties have been amenable to the issue, and they've worked with each other. Obviously, they have a vested interest in the success of the brand itself. So it's something to take a look at, I think, going forward in terms of that language, and revisit as necessary. But something to keep in mind. I want to keep us moving here to a degree, because we do have a lot to cover. The next issue up is really vaccine mandates, and we've gotten a ton of questions at this point on, you know, what is permitted given where we're at in terms of the vaccine getting widely distributed at this point. I know that Planet Hollywood has their approach, and again, this is another area where the conversations that I've had, you know, the industry as a whole is really lockstep with Planet Hollywood's approach as well, and that is they're not going to be mandating any type of vaccine with their employees or via their franchisees. But the questions that have come in has really been, may employers mandate employees taking the COVID-19 vaccine? And the simple answer to that is yes. That is permissible. The EEOC and the U.S. Department of Labor have issued specific guidance on that front, saying that employers are permitted to mandate that employees do get themselves vaccinated. But it is a slippery slope. There are a lot of issues to be conscious of, be aware of out there, mainly as it relates to any type of exception for religious affiliation, Americans with Disabilities Act, reasonable accommodations under the ADA, things of that nature. So it's a bit beyond the scope of this discussion. I'll say that you know, vaccine mandates are permitted, but be aware of the issues that are out there in terms of exemptions. A few practical considerations: if you're going to mandate vaccines, make sure you have some form of written policy on the books there, and regarding the request for a reasonable accommodation, you want to make that known as well to your employees. Keep the vaccination records separate and apart from general personnel files. The purpose there would be maintaining confidentiality. Obviously, there are issues regarding HIPAA and other federal laws, as mentioned there, ADA, et cetera. Consistency and implementation is also another area that is of the utmost importance. So I would say consult counsel, consult your employment counsel, to the extent that you are looking at any form of mandated vaccination. Gio, I don't know if you wanted to make any further comments there in terms of where you guys are at.
Yeah, I mean, yeah, like we talked about, that we're pretty lockstep with the rest of industry, not requiring any mandates, but we do, strongly encourage it, and we're making sure that we regularly communicate with our employees and the restaurants and the managers on relevant and up-to-date vaccine distribution and whatever demographic it's open to at the moment, to give them as much information as possible to have them comfortable and get out there and get a vaccine, because that's just going to help us in terms of the consumer sentiment, consumer comfortability with going back out and dining in and stuff like that. And I mean, most people should have, or most companies should have pretty good resources from their health insurer or their benefits program, which we have UMR, and they have a good resource, and it's an interactive document where you kind of click on it, and it takes you to one of their web pages, and you type in your zip code, and then it just gives you all the kind of resources for that area, that city, or whatever.
Perfect. So let's keep it moving here. Let's run these through a bit quicker. I think I'm going to need to, given the amount of material that we have here and the timing that we have. So we talked about force majeure provisions, obviously within the franchise agreement itself. These issues come up as well, and you're going to want to revisit any type of force majeure provisions in rental agreements as well as your franchise agreements. And finally, any type of vendor or supply agreements. There may be mandated volume requirements in certain contracts that are maintained. You want to review and get a better handle on what type of force majeure provisions or act of God provisions you may have in there that provide some relief with respect to performance under those contracts. Indemnity we talked about as well. You want to make sure that any indemnification language is broad enough to encompass some of these changes that are going to take place operationally. We didn't get into it too in depth there, but we talked about third-party app and delivery services. You want to make sure that any type of contract that's entered into, either at the franchisee level or the franchisor level, you have sufficiently broad indemnification language, so you have that pass through to the extent that there is any liability that is garnered at the franchisee level. So it's another important aspect of contracts and risk transfer itself that you want to take this time and take this opportunity to review and get a better handle on. Lastly is insurance, and why don't we dive right into that now? We're going to get into a few different lines of coverage, and then we can, again, leave a little time for questions that are out there right now. So I wanted to mention a few things before we get into the insurance stuff, just kind of a precursor. Insurance companies generally have done a great job, I would say, from day one, once the pandemic really took hold, and once we started to see governmental orders, shutdowns, shelter-in-place orders, back to that March 2020 timeframe that I brought up before. We've seen them do a great job in terms of getting out the idea, getting out the campaign that coverage is simply not available in terms of business interruption, what I'll call first-party property coverage claims. On that front, generally speaking, most insurance policies are not going to be the same across the board. You can have manuscripted language, custom language included therein. You're going to have different lines of coverage that are incorporated into, say, a business owner's policy that could include both general liability as well as first-party coverage, commercial property coverage. So with that in mind, again, take this opportunity to either with your broker, with coverage counsel, whoever you have in your corner there that may be able to provide some guidance. Take this time now to review those policies, get an idea of where those issues stand and what coverage is really provided. don't believe the hype, I guess you can say, when it comes to the message that's been put out there by most insurance companies at this point. Coverage may be there to a degree, but you're not going to know unless you do that review. And what we've seen really is a number of insurance companies and attorneys jump into the mix haphazardly when they don't necessarily have the experience in the coverage area. And most have filed suit right off the bat without really doing an analysis and determining whether or not the coverage and the language itself of these policies, as well as the factual situations that are being dealt with, are advantageous and really merit going to litigation. So just kind of a precursor there. So let's dig in now, since we've only got maybe another 10 minutes here. First and foremost, what's been on the minds of most franchisors and franchisees, and more so, is commercial property coverage. And this is first party coverage. Commercial property policies generally provide for a variety of property damage and business interruption risk. General rule is you're going to need some form of property damage, either direct physical loss and or damage to covered property for purposes of triggering relief under these forms of coverage. What we've seen is that most insurers have argued, if not all, that the presence of coronavirus or infection itself on insured property does not constitute the property damage or physical loss that's required for purposes of triggering coverage under these property forms. There are a number of cases more recently that have come out that support the idea that the presence of coronavirus alone at least has the potential for serving as the necessary property damage for purposes of triggering coverage. So that's important to keep in mind. Going back to what I said earlier, there's been a rush to the courthouse steps by a number of counsel that may not be versed in these coverage issues. And from the beginning, we've seen a number of decisions that have come out that are not favorable and that really have been relied upon early on to discourage and discredit any further attempts to obtain coverage by policyholders under a property form. So it's important to stay abreast of where those decisions stand, and again, review your own policies and keep in mind what the scope and limitations are that are applicable to you. So that's going to be a key issue that the courts will continue to address going forward, that presence of coronavirus either on or near a site as being direct physical loss or damage for purposes of triggering coverage under first party property policy. A number of recent decisions that have come out that are going to play a role going forward. We don't need to get into them right now necessarily, but there is litigation across the country that remains ongoing at this point. And that issue of direct physical loss is really at play. The other issue that I wanted to get into quickly is the idea of virus exclusions. To the extent that we are able to get over that hurdle of a direct physical loss or damage and having that initial condition or trigger of coverage under these first party property policies, the next issue is whether or not there's a presence of virus exclusion on these policies. And these can vary as well. It's another important issue to maintain and understand that language matters. You need to be aware of what the specific exclusion states, and keep in mind that the courts in nearly all jurisdictions interpret exclusions very narrowly, and it's the burden of the insurer to prove that a relevant exclusion applies to limit or eliminate coverage. So it's important to keep that in mind. So civil authority coverage is another form of first party coverage here. And there's as an example, property damage itself not always need to occur to your operation or your facility, the insured premises itself. Civil authority coverage provides coverage for losses caused by acts or orders of civil authority. So going back to the shutdown orders, the shelter-in-place orders that we began seeing back in March of 2020, this civil authority coverage is really where we would look to see some relief being provided. This is fertile ground here for a number of claims. Lost profits stemming from such actions or orders of civil authority that prohibit or prevent or impair access to your operation. That's really where we're going to be looking at this type of coverage. Some policies are going to require, again, that the access itself be prohibited. In most situations, you're going to have that requirement or condition of physical loss or damage as well. Again, not necessarily to the insured premises, but there is an element of damage, physical damage, that's likely going to be required. A couple of things to keep in mind here as well. You can see on the slide, there's typically going to be a sub-limit in terms of the period of coverage, either 30 days, I've seen up to 90 days as well. It's important to keep in mind when you're documenting and determining your scope of losses there, that there is typically some level of time frame requirement or limitation there. So the last point I wanted to make with respect to civil authority coverage is you're generally going to have some form of a geographical limitation as well. So when there's a requirement of that direct physical loss or damage outside of the insured premises, you're going to see maybe 1,000-foot or up to a mile restriction, which requires that property damage actually occur within that space for purposes of triggering coverage. So a couple key points there to keep in mind on the civil authority coverage. And we're getting a bit late here. So ingress and egress is another form of property coverage that you're going to want to keep in mind there. It doesn't necessarily require that order, that governmental order that the civil authority coverage would, but you need that restriction to the property from going forward in order to trigger that ingress and egress coverage. So let's move on here to more third-party coverage and liability coverage. CGL coverage itself, it's really designed to cover policyholders against claims brought against them by others, obviously alleging some policyholder conduct caused either bodily injury or property damage, obviously such as sickness or disease resulting from exposure to harmful conditions, including what we would see here with COVID-19 and the coronavirus. It's standard coverage that you're going to want to have in place, and it's typically part of the package that any franchisor is going to require of their franchisees as well. We've seen some cases of late that are dealing with CGL coverage related to COVID-19 that have found that coverage is available with respect to claims coming in. Obviously, you want to be aware of certain relevant exclusions, including communicable disease exclusions, virus exclusions, and any type of manuscripted exclusions that may be applicable to such claims or liability as well. Workers' compensation. So we've seen some promising results here as well with respect to workers' comp. The question that comes up most, and really the heart of the issue, is causation. How and where did the worker contract the disease itself? Because it's obviously an issue of whether or not that employee who's making that claim for workers' compensation benefits contracted the disease within the scope of employment. Obviously, it's a difficult issue to address and determine. So what we've seen here from nearly all states at this point is the enactment of a rebuttable presumption And basically what that says is that there is a rebuttable presumption that to the extent a claim is made by an employee, that they do not need to show that level of causation. The rebuttable presumption basically looks at the issue as if, and again, presents and creates the presumption that it was in fact contracted while in the course and scope of employment. Obviously, employers have the ability to dispute that, but it essentially flips the burden at that point upon the employer to show that it was not in fact contracted while in the scope of employment. So you see a number of states there. Like I said, at this point, we have nearly all states that have enacted some form of rebuttable presumption. Something to keep an eye on, though, is many of those states and the regulations that they've enacted either have some form of a sunsetting provision, or we anticipate that there will be some point in time where those regulations are not continued. So it's important to keep them in mind going forward and stay on top of any type of legislative action that occurs. Additional lines to consider: cyber liability, auto liability, franchisors, E&O. I did want to mention the cyber and auto with respect to, again, the delivery services. If you as a franchisor or as a franchisee don't have cyber liability coverage, it's important, given the level of digital automation that's going on and is present at the franchisor and franchisee level, your POS system, customer and employee records. It's important to at least explore cyber liability further. And again, with the expansion of delivery service, use of apps, et cetera, it's only going to become more important. So something to keep in mind. Legislative responses, we'll run through these quickly as well. There have been a number of states, I believe it's up to 11 at this point. Obviously, New Jersey, Ohio, Massachusetts, and New York are the forerunners there that we saw action out of initially. At the federal level as well, there have been a number of legislative endeavors that have been introduced at both, again, the state and federal level. They've stalled somewhat. We haven't seen much action at either level at this point, but I would anticipate seeing further action at the federal level. I think that any relief that is put forth at the federal level is really has the best shot of dealing with the wide scale issue and the wide scale losses that have been experienced, for the small businesses and the franchising community as a whole. So keep your eye out for PREA and the pandemic risk reinsurance program going forward. And lastly, before we get into some questions here, I wanted to bring up some further information on the resources that we have available on our COVID-19 website page. We have a map here, a snapshot that I wanted to include that includes both legislative relief as well as state jurisdictional issues and decisions nationwide. So it's a great resource that covers more in depth all of the issues that we've talked about today and more. So check that out if you have some time. And lastly, I just wanted to provide some further key policyholder takeaways. Again, we touched upon this earlier: review your insurance policies carefully. Not all policies are the same. It's important to work with your broker, coverage counsel, to be aware of, again, the nuances and the scope and limitations that you may be dealing with in terms of your own coverage. Provide notice early and often. There is no impact to loss records. There is no impact necessarily to premiums if notice is provided of a claim. So it's important to provide that notice. Document your losses carefully. Keep those lines of communications open. And I mentioned this earlier, but be mindful of relevant dates and applicable statutes and suit limitation provisions that may be in your policies. And it was a bit rushed there, but if we wanted to, well, first off, Gio, do we want to state anything further here? I rushed through it a bit, but I wanted to give you an opportunity to chime in on any further.
Yeah, just add a couple things. You know, you mentioned cyber liability, and what I have to say about that. Really, not too much COVID related, but you know, it's an ongoing issue, and I think most companies will attest to this. Is that, you know, it's becoming more and more of a legitimate business of kind of cyber hacking in parts of Europe, Eastern Europe, and things like that. And it's becoming a very repetitive issue. So it's something that we're keeping an eye on for sure. And then the other thing, you know, there's only so much you'll be able to do with your contracts with the third-party delivery apps, because they're kind of the Google or Apple of the delivery app industry, or the third-party delivery industry. So pretty immovable, but you know, do what you can.
Right, many have their own form agreements. Then they're not necessarily looking to accept any changes that may be presented to them, right?
Correct.
So with that in mind, Caitlin, why don't I throw it to you now, and we can see if there are any questions. I know I ran a bit over here, and I apologize for that.
Oh, thank you guys. Thank you, Richard. Thank you, Giovanni. Thank you for everybody for attending. We do not have any questions right now, but we're also out of time. So Richard, do you want to give your email if they have any questions that they can email you about?
Sure, here's the contact information. Thank you again, everyone, for attending. And you in particular, Gio, I really appreciate you jumping in here and providing some thoughts here in terms of your experience. So.
Yes,
Great.
thank you
My
both
pleasure.
so much. Thanks to Saks, Dornberger, and Vita for their sponsorship. And again, this was recorded as well. The PowerPoint and this recording will be available on community.franchise.org in the next few days. So if you want to re-listen or have any questions, you can check out the recording, the PowerPoint, or of course, contact Richard directly. Thank you all so much. Thank you again, Richard, Giovanni. Have a great afternoon.
All right,
As
you
well.
too. Thanks. Bye.
Thank you.